To control corruption and ensure accountability in public administration, India established institutions like Lokpal at the union level and Lokayukta at the state level under the Lokpal and Lokayuktas Act 2013. These bodies act as anti-corruption authorities for investigating complaints against public officials. 1. Meaning of Lokayukta and its jurisdiction. Meaning: Lokayukta is a state-level independent authority appointed to investigate allegations of corruption, misuse of power, and maladministration by public servants. Simple understanding: it is like a watchdog at the state level that checks whether government officials are working honestly. Jurisdiction of Lokayukta. Jurisdiction means the area and persons over which Lokayukta has authority. Lokayukta generally covers Chief Minister, in some states with limitations, ministers and members of state legislature, government officials and employees, local bodies and public authorities. Matters covered: corruption, abuse of power, delay in administrative work, unfair or arbitrary decisions. Limitations: cannot interfere in judicial decisions, may not have power over private individuals. Powers vary from state to state. 2. Main provisions of Lokpal and Lokayuktas Act 2013. The Lokpal and Lokayuktas Act 2013 was enacted to create a strong mechanism to deal with corruption at both central and state levels. 1. Establishment of Lokpal. Lokpal is set up at the central level. It consists of a chairperson and members, judicial and non-judicial. 2. Composition. Chairperson, former Chief Justice of India or Supreme Court judge or eminent person. Members, maximum 8, 50% judicial members. At least 50% members from SC Cent OBC women minorities. 3. Appointment process. Appointed by the President. Selection committee includes Prime Minister, Speaker of Lok Sabha, Leader of Opposition, Chief Justice of India or nominee, eminent jurist. 4. Jurisdiction of Lokpal. Covers Prime Minister with some restrictions. Ministers, Members of Parliament, Group A, B, C, D officers, certain NGOs receiving government funds. 5. Inquiry and investigation. Lokpal can order preliminary inquiry. Investigation conducted by agencies like CBI. Time-bound process. 6. Prosecution powers. Lokpal can recommend prosecution. Special courts are established for speedy trial. 7. Lokayukta in states. Act requires states to establish Lokayukta. Structure and powers decided by state laws. 8. Declaration of assets. Public servants must declare their assets and liabilities. 9. Protection for whistleblowers. Provides safeguards to persons who expose corruption. 10. Time-bound disposal. Inquiry and investigation must be completed within a fixed time. Importance of the Act. Strengthens anti-corruption system. Promotes transparency. Ensures accountability of public officials. Builds public trust in government. Conclusion. Lokayukta and Lokpal are important institutions for controlling corruption in India. While Lokayukta works at the state level, Lokpal functions at the central level. The 2013 Act provides a strong legal framework to ensure honest governance, though its effectiveness depends on proper implementation.